All right, Ms. Heisel, I believe that we're live on YouTube at this time.
Thank you, Judge.
Yeah, sorry about that. All right, let's see who we have next. I believe that takes care of everyone appearing via Zoom. So if we have anyone in the courtroom that's ready, if you'll step up and give me some direction, I would appreciate it.
Judge, we're ready to reset Mr. Knight.
All right, and let me see. I think I had a note on Mr. Knight. All right, did Mr. Knight, Mr. Manning, did Mr. Knight come on up? Come on up to the podium. This is CR 19-317, State versus Darren Bertram Knight. And Mr. Knight, did you report to pretrial release like I ordered you to discuss your delinquency and payments?
Yes, sir.
All right, Mr. Manning, have you discussed with Ms. Burns any of his delinquency issues?
I've spoken to Mr. Waddell, and he said he's addressed that with Mr. Knight.
Okay. All right, Mr. Knight is set for pretrial today. Are there any contested pretrial motions, Mr. Manning?
So, Judge, we received all discovery in this case as of yesterday, late yesterday. We received the final supplement from the DA's office. We reviewed that and would ask to be set on a docket call. We received an offer as well, and we're continuing negotiations at this point in time.
Okay. There being no contested pretrial motions, the court will set this for docket call, and we will set this for docket call on August 25th, unless you have a scheduling conflict, Mr. Manning.
No, Judge, that'll work.
All right. Then, Mr. Knight, you're ordered to appear in person on August 25th at 9 a.m.
Yes, sir.
And I believe, Mr. Manning, are you executing a notice of appearance?
Yes, sir.
All right. Thank you, sir.
Judge, I'll go speak to the one that I was just given by Mr. Abraham.
Okay. Yes. Are you going to step out to speak with your client on that one? Good morning, Ms. Millentree. How are you?
I'm well, and you, y'all?
I'm doing great. Is Mr. Brown there? I don't believe he was there earlier when I called his name.
He's right here, y'all. And I went and spoke to Ms. Abraham, and when she received a return mail, but at the same time, she told me to go and speak with Ms. Burns. I think Ms. Burns personally told him to be here this morning. I just spoke with Ms. Burns, and Ms. Burns did tell Mr. Brown to be present, so he's not here yet. The main purpose of the status hearing was due to the fact he was not adhering to the conditions of probation.
Is Ms. Burns in there?
When you speak up, I can't. She's on her way, Judge.
Thank
Can you
you.
hear me?
Ms. Burns, on Ronald Franklin Brown, my docket says that it was a status of on probation, and Ms. Millentree's indicated that the main purpose of today's hearing was due to find out whether or not he was complying. And I believe Ms. Millentree said, I think there's an issue that he's not complying with his conditions of probation. Is this the one that you had approached me about regarding whether or not we set him, since we're not having sanctions court?
Yes, sir.
Okay. All right. And kind of what is the status of Mr. Brown and his compliance with his probation conditions?
He's reporting that he has not taken his meds, he's not paying, and not performing.
And do you believe that he's going to be here this morning as ordered?
We notified him to be here, so.
Okay. Do you anticipate the department to be requesting the state to file a motion to adjudicate or revoke his community supervision? Okay. Since Mr. Brown is on probation, I think that would be the next step rather than trying. I don't believe that he's on bond right now. Is that correct? Yeah. That being the case, then I'll leave it with you and the state. Court was going to attempt some type of court intervention on Mr. Brown to encourage him, as Ms. Millentree said, to start complying with his conditions of community supervision. Typically, we would do this during our sanctions court program, but that program has been suspended due to the COVID virus. So Mr. Brown's refusal to appear today as requested and ordered prevents the court from doing that intervention. So, and urging Mr. Brown to comply with his conditions of community supervision and or face the consequences thereof if he doesn't. So his refusal to be here today speaks loudly to the court. So I'll leave it I'll leave it to the state to decide what they want to do with Mr. Brown, but I would encourage a consideration for a motion to revoke or adjudicate.
And Your Honor, for the record, a part of his probation, Mr. Brown was ordered to take his medication. We went through and had a psych evaluation. He was doing very well. Not taking his medication, and Ms. Burns brought that to my attention.
Judge Martin, can you hear me? Judge Martin, if you can hear me, it appears your screen is frozen.
He probably left and then coming back. Yeah, when they go on YouTube, but you don't,
Can you see and hear me okay? I think I lost
Can
connection.
now.
Okay, good. Sorry about that. All right, so I'll leave it within the state to speak with Ms. Burns about how to move forward. Anything further, Ms. Military?
No, Your Honor, my excuse.
Yes, ma'am. Thank you. Good to see you. Do we have anyone else in the courtroom with counsel that is ready?
Not yet, Judge.
Not yet. Okay. All right. So Ms. Chevalier, CR 18467, if you'll come to the podium, please. All right, Ms. Chevalier, you are Brandy Michelle Chevalier, is that correct? This is CR 18467. Ms. Chevalier, you are set for arraignment today on a state jail felony offense of theft of property, $2,500 to $30,000. Are you going to hire an attorney to represent you in this matter?
Right now, Judge, I can't afford to hire one.
I'm sorry, say that again.
Sorry, right now, Judge, I can't afford to hire an attorney.
Do you believe if the court gave you some time, you would be able to acquire the funds to hire an attorney to represent you? You're going to speak up. I can't hear you.
Sorry, no, sir, I won't be able to afford an attorney right now.
Do you have a job?
No, sir.
You don't have a job?
No, sir.
Do you have any assets? Do you have cars or bank account or stocks or anything like that?
Well, I applied for my unemployment. I'm still waiting back to see if I got approved.
Are you requesting the court to appoint you an attorney?
Yes, sir.
All right, then what I need you to do is exit the courtroom and go down the hallway to the last office on the left and speak with Miss Patty Taberham. She's the indigent coordinator, and she can give you some paperwork, and you'll need to fill that out regarding your income and expenses and debts. And then the court will review that and determine if you are indigent. If so, then the court will appoint you an attorney. If not, then the court will not, and you'll have to figure out how to hire an attorney, okay?
Yes, sir.
All right, so go ahead and exit the courtroom and go see Ms. Taberham. Once you have completed your paperwork, then you're ordered to reappear in the courtroom.
Yes, sir, I can do it.
All right, thank you.
A few minutes
Yes.
later, you complete that paperwork.
Ma'am, say that again.
I'm sorry, she got here a few minutes late, but she has since completed that paperwork with
Oh,
Ms.
she
Taberham.
has. Okay, all right, then I'll wait to hear from Ms. Taberham. Did Mr. Rudolfo Gonzalez, is he in the courtroom?
He is, sir.
All right, Mr. Gonzalez, if you'll come up, please.
And double check with him, Judge, but I think he also has completed his paperwork with Ms. Abraham.
If you'll ask him that, bailiff.
He says he has.
All right, so I'm sorry. All right, Mr. Gonzalez, go ahead and have a seat. And once that paperwork is brought to my attention, then I'll call you back up, okay? Mr. Manning, are you ready on Mr. King, Zane Oakley King? All right, Mr. King, if you'll make your way to the podium, please. Mr. Manning, have you had an opportunity to review the indictment in this case with Mr. King?
Yes, sir, we have.
Okay, all right. And are you ready for arraignment, Mr. Manning?
Yes, Judge, we waive the reading of the indictment. His name is spelled correctly in the indictment. He understands the charges that are alleged against him, and at this time, he's pleading not guilty.
All right, the court will have the record reflect that Mr. King has waived the formal requirements of arraignment, that he enters a plea of not guilty. The court accepts that plea of not guilty, enters that into the record, and the court will find that Mr. King meets the requirements of indigency and has appointed the Honorable Jonathan Manning to represent him. And this case is therefore set for pretrial on August 25th at 9 a.m. And Mr. King, have you already signed your conditions of pretrial release?
No, sir, I don't think so.
Judge, he said he doesn't believe he has.
Okay, then what we'll need to do then is, Mr. Manning, after you do the notice of appearance, then let's have him go ahead and receive his conditions of pretrial release. If Ms. Burns is in the courtroom, you just direct him to Ms. Burns, and let's go ahead and have him fill that out and give him a copy, and then I'll sign it. I'll sign it later. Let's go ahead. Mr. King, I'm going to order conditions of pretrial release. Ms. Burns is going to give you a copy of those. It's not going to bear my signature until after today, but they will be effective upon you. And as you have received court-appointed counsel, Mr. Manning, it's going to be your bond in this case is going to be conditioned upon several things, and you're going to get a copy of that paperwork, and it's going to show you what you're required to comply with. One of those is going to be reimbursing the county for the appointment of Mr. Manning. Do you understand?
Sir.
All right. So once you receive your notice of appearance, just Mr. Manning, if you'll have him sit in the jury box, and then ask Ms. Burns to prepare the conditions of pretrial release. Once he signs those, then he's free to go.
Yes, sir.
All right. Thank you, Mr. Manning.
Judge, this time I would be excused.
Yes. Well, you may be excused, and Mr. King can be excused once he signs his conditions of pretrial release.
Yes, sir. Thank you. Thank you.
All right. I'm assuming that Mr. Adams is still working on preparing the plea papers on his clients.
I believe so, Judge. He is not in the courtroom. Mr. Sanders is indicating he also needs another minute or two.
That's fine. What about Mr. Gimbel? Is he here?
He is not here, no, sir.
Ms. Baker, if you're watching the Zoom, if you wouldn't mind contacting Mr. Gimbel to see where he's at. I don't see any notes that he's running late. And Mr. Gimbel's client is present in the courtroom, I believe. Is that correct? Mr. Murph, Colton Murph is present in the courtroom?
Colton Murph? He is, yes, Your Honor.
Ask him if he's seen or heard from Mr. Gimbel today.
We call him in from straight to this bill.
Judge, they say that they've tried to reach out to him, but it's gone straight to voicemail, and they have left a message.
All right, thank you, Mr. Murph. Just have a seat, and we'll see if we can contact Mr. Gimbel and get him here.
Judge,
Yes.
on Zane King, would you advise me on what you would like for me to check on his condition?
Yes, if you'll hold him up, I'll tell you. If you hold him up to the camera. Closer. Or I can put my glasses on. All right, a little bit higher. All right, so we're gonna do 1, 2, and what is he charged with? He's charged with theft, is that correct?
Yes, sir, theft of property.
Theft of property? Okay, let's do conditions 1 and 2, and then we want, I think it's, what is it, 9, that's the no, to abstain?
That would be 7.
All right, 7. What is conditions 4 and 5 are the no contact with victims, right?
That's correct. 3 is your analysis.
Yes, so 1, 2, and 3.
And then 6 is to pay 10 or 40.
Yes, we'll do 6 and it'll be 10.
Okay. And then 7 is to abstain.
7, yes.
And 9 is if you want him to take any classes.
No.
And then 11 is the court-appointed attorney to pay $50 a month.
Yes to 11.
Okay. And 12 shall not possess or use a weapon.
Yes to 12.
And that's it.
Okay. Yeah, if you'll go ahead and have him sign it and just give him a copy,
Okay.
then I'll sign it when I get a chance.
Okay. Would you like for him to report monthly or weekly?
I think monthly is fine at this point.
Okay. Thank you.
All right, I believe that we've covered everyone except our people that are requesting court-appointed attorneys, Chevalier, Gonzalez, and King. No, we've handled King. The first two, Chevalier and Gonzalez, on the course docket, page 1. And then, of course, Mr. Adams' clients and Mr. Gimbel's clients. I think we've had announcements on everyone else. Mr. Sanders' clients.
Judge Martin,
Yes, ma'am.
Sanders says he believes he's ready on the plea with Mr. Llewellyn.
Lee, on Mr. Llewellyn. Okay. All right, Mr. Llewellyn, go ahead and have him come to the podium.
Hendricks got passed.
All right, for the state, who's gonna be doing the plea? Who's familiar with the terms?
That's me, Your Honor.
Okay, can you go ahead and kind of lay that out for me?
Yes, Your Honor. This is a F-star. We are proceeding under the misdemeanor punishment provision, which is up to a year in county jail. Our recommendation is for 45 days county jail. I believe, I don't have the plea paperwork in front of me, but I believe Mr. Llewellyn has 1 day credit towards that, and is planning on serving the rest of that sentence out. We are going to waive a fine, but there is restitution that I know it's over $2,000, Your Honor. I would ask Mr. Sanders in the courtroom to recite exactly what that restitution is, and then court costs and reimbursement to the county.
Mr. Sanders, can you, if you look at the judgment, can you tell me what the restitution amount is?
Yes, Your Honor, it's $2,481.
$2,481. And what about court costs?
$290 for court costs.
And are there any reimbursement fees?
Yes, $785 total.
785. And is Ms. Heisel correct? 45 days in jail is the recommendation with 1 day credit?
Yes, that's correct.
And Mr. Llewellyn will be going in custody today?
Yes, that's correct.
All right, and this is a hybrid felony with a, what's the conviction level? Is that, I see that it's a misdemeanor punishment. Is it a felony conviction?
It still would be a felony conviction, basically a third degree.
So a third degree conviction with misdemeanor punishment.
Yes.
Okay. All right, Mr. Llewellyn, if you will, raise your right hand. I'm going to place you under oath, sir. Mr. Llewellyn, do you swear that the testimony you give to the court today in this matter, that it will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. All right, Mr. Llewellyn, you are David Wayne Llewellyn, is that correct? And Mr. Llewellyn, are you a United States citizen?
Sure.
Do you read, write, and speak English?
Sure.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation of you?
Yes, sir, 100%.
Good. Do you feel like you've had sufficient time to go over your case with him and have all of your legal questions answered?
Sir.
Is there anything about this plea agreement that you feel that you do not understand?
No, sir, not at all.
Mr. Sanders, do you believe Mr. Llewellyn to be competent today?
Yes, I do, Your Honor.
And you've explained to him all of his legal and constitutional rights?
Yes, I have.
And you feel he appreciates and understands the circumstances and consequences of his plea before the court today?
Yes, I believe he does.
Okay. Mr. Llewellyn, you are charged with the felony offense of accident involving injury, which carries a range of punishment of up to 1 year confinement in the Van Zandt County Jail and a fine not to exceed, is this the $5,000 fine?
5,000, yes, Your Honor.
And a fine not to exceed $5,000. However, it's my understanding that you've reached a plea agreement with the state in which their recommendation is that you be convicted of this offense, and therefore you would be a convicted felon, and that you be punished with sentence up to 45 days confinement in the Van Zandt County Jail, with you receiving 1 day credit. Do you understand that range of punishment? And do you also understand that the plea agreement would fall within that acceptable range of punishment?
Yes, sir.
And you're asking the court to approve that plea agreement and accept that?
Yes, sir.
Okay. So then, Mr. Llewellyn, then to the felony offense of accident involving injury, how do you plead? Guilty or not guilty? And Mr. Llewellyn, are you pleading guilty because in fact you are guilty and for no other reason? And has anyone threatened you, forced you, or otherwise pressured you to plead guilty to this offense when in fact you're not guilty? All right, the court will accept Mr. Llewellyn's plea of guilt at this time. Mr. Sanders, is there any objection to the admission of States 1, stipulation of evidence?
No objection.
All right, court admits States Exhibit 1, stipulation of evidence, and takes judicial notice of Mr. Llewellyn's judicial confession. Is there anything further from the state?
Oh, Your Honor.
Anything further from the defense?
No, Your Honor.
And Ms. Heisel, are you able to give me a summary of the facts in this case?
Yes, Your Honor. The day after Christmas, Mr. Llewellyn was driving and rear-ended Mr. Kempton at a red light, which completely totaled his brand new vehicle, a pickup truck. Mr. Llewellyn initially pulled over and then fled the scene of the accident. Luckily, there were some good Samaritans who had witnessed that crash. One of them followed Mr. Llewellyn while on the phone with law enforcement, basically back to Mr. Llewellyn's house, where law enforcement was able to contact him and ask him about the accident, where he admitted that basically he had just gotten spooked and decided to leave. Mr. Kempton was injured pretty substantially, had to be transported by ambulance to Tyler to the hospital with some back and neck concerns. Luckily, he escaped without any long-standing injury, which is why this is not a more serious felony punishment range, but was injured nevertheless. And Mr. Llewellyn admitted to law enforcement that he had hit him. He tried to hit his brakes, but was unable to avoid him, and then got scared and left the scene of the crash.
Thank you, Ms. Heisel. Mr. Sanders, any objection to that summation by Ms. Heisel?
No, Your Honor.
Okay. All right, then based on the evidence before the court will find that there is sufficient evidence to convict David Wayne Llewellyn of the felony offense of accident involving injury. The court will follow the plea agreement in this case. The court hereby convicts Mr. Llewellyn of that offense assesses his punishment at 45 days confinement in the Van Zandt County Jail. The court issues a 1-day credit to Mr. Llewellyn for time served on this case. Court assesses a 0 fine. Court assesses restitution in the amount of $2,481, court costs in the amount of $290, and orders him to reimburse Van Zandt County in the amount of $785. Mr. Llewellyn, whenever you leave the custody of the Van Zandt County Jail, I'm going to order you to appear here at the courthouse and meet with the court compliance officer located there on the same floor of the courtroom. Her name is Bonnie LaPrade, and I want you to meet with her to discuss a payment plan to take care of your court costs and reimbursement fees and restitution. Is the restitution being paid out, or is that being paid up front, Ms. Heisel?
Your Honor, I am not sure. I believe it will be on a payment plan unless Mr. Sanders has information I don't have.
That's correct, Judge. We were asking for this to be paid on a payment plan. We talked about trying to get, if not all, at least partial, partial down payment, but Mr. Llewellyn wasn't able to do that, so he'll just have to be paying out the restitution.
And who is the restitution payable to?
It's to Todd Kempton, the victim, Your Honor.
Okay. So, Mr. Llewellyn, it's very important that you understand that your failure to make arrangements to pay your restitution, your court costs, and your reimbursement fees, your failure to do that will result in the court issuing a warrant for your arrest and putting you back in jail for failure to pay those financial obligations. Do you understand that? The better option would be for you to report after you are released from jail and make a payment plan. And then as long as you're making a significant effort to comply, then the court will continue to work with you. Okay. All right. So, Mr. Llewellyn, you're hereby remanded to the custody of the Van Zandt County Sheriff so we carry out the terms and conditions of the sentence. I'm going to have you step over with my bailiff to be fingerprinted, and then bailiff, you're to take Mr. Llewellyn into custody.
Yes, Judge.
Mr. Sanders, if you'll leave the plea papers and your motion to pay with the bailiff, I'll get those signed.
Okay, thank you. And Judge, I have one other client who's on the docket, but I don't believe that she is here, Karen White. She's here.
Yes, is Miss White not in the courtroom? She wasn't earlier.
Oh, I'm sorry.
Okay. Then we'll have her name called and the court will issue a judgment nisi for her.
All right, thank you.
Do you have anything on this afternoon's docket, Mr. Sanders?
Yes, I do. So I'll be seeing you this afternoon.
Okay, great. All right. Thank you, sir. Mr. Adams, are you ready on any of your clients or do you still need some more time? And I'm not rushing you. I'm just inquiring.
Your Honor, I need about 5 more minutes and I'll be ready to go.
Yes, sir. No problem. Bailiff,
Yes, Judge.
if you'll catch Mr. Sanders before he leaves, I believe that he's been appointed some new clients. Oh, never mind. I see Miss Tabraham. She's intercepted him. She's not going to let him get far. All right, State, I'm going to stand in recess for just a few minutes. I'm going to try to be able to sign some of these appointments. So I'll be out for just a moment. Mr. Adams, are you ready, sir?
Yes, Your Honor, we're ready.
And who are you ready on?
I'd first like to start with Mr. Kevin Wood.
All right, Mr. Wood, if you would make your way to the podium, please, sir. This is CR 20-96, State versus Kevin Lee Wood. My docket says that we're set for pretrial. Is that what we're proceeding on today, Mr. Adams?
That's right, Your Honor. We in fact have a couple of different plea offers from the state, excuse me, that we're considering. Mr. Wood and I have only been able to recently discuss them, and he's asked me to ask the court for a reset so that he can consider those offers as they would affect his employment situation, and so that he can visit with his family about that. I don't think that we need too much time, and I don't have any pretrial issues for the court to take up this morning. I'm very confident this case will be resolved with a plea. We just need to figure out which one to take.
Okay. All right, then there being no contested pretrial issues, then the court will just set this for the court's regular docket call. We'll set that on August 25th. Does that give you sufficient time, Mr. Adams, to figure out what you need to figure out?
Yes, Your Honor. That was 26.
25th, I believe. Let me double check. Yeah, that'd be August 25th
Very good, Your Honor.
at 9 a.m.
Okay. Thank you, Your Honor. Mr. Wood, free to go.
Yes, once he signs his notice of appearance, then Mr. Wood will see you back on August 25th at 9 a.m., sir.
Your Honor, I'm next ready on Michael David Mason Sr.
You said Michael Mason Sr.?
Correct, Your Honor.
All right, Mr. Mason, if you will make your way to the podium, CR 20-55, State versus Michael David Mason. And we're set for pretrial in this case also, Mr. Adams?
That's correct, Your Honor. Received a plea offer yesterday from the state in how, despite the fact that there's only been about 12 hours since receiving it, I've talked to Mr. Mason about it. He was not willing to accept it. In fact, wants a jury trial. I do not have any pretrial matters for the court to take up today.
Okay. Then what we'll do is the court will set this for its regular docket call on August 25th. And perhaps Mr. Mason can make any counter offers he deems that would be acceptable to him. And we can get a final announcement from both the state and Mr. Mason on whether or not we're going to be able to resolve this case without a trial. So I'll be looking to hear about that on August 25th from Mr. Mason, that we've extinguished all possibilities of plea agreement.
Yes, Your Honor. I do not believe that there are any outstanding discovery issues. I'll have to double check. If there are, it would be a matter of audio-visual materials, which are easily obtained.
Okay. And state, are we having, we still having success in uploading videos and digital evidence to the shared portal for discovery?
Getting there, slowly but surely.
Good. Okay. All right, Mr. Mason, we'll see you back on August 25th.
Your Honor, I have Ms. Brandy Chevalier set for arraignment this morning.
Okay. CR 18-467, Brandy Michelle, is it Chevalier or Chevalier? How is that pronounced? How is that pronounced? I'm sorry, say it one more time. Okay. All right, and Mr. Adams, are you prepared for arraignment this morning? Have you had a chance to review the indictment with your client?
We're ready to proceed, Your Honor. Ms. Chevalier, I'm showing you what's a copy of the state's indictment in this matter, and the state has the state spelled your name correctly?
Yes, sir.
Now, Ms. Chevalier, you understand what it is that you're charged with in this indictment, right?
Yes, sir.
What they say you did, not that we admit that, but you understand what they say you did, right?
Yes, sir.
At this time, we're entering a plea of not guilty, is that correct?
Yes, sir.
And Your Honor will waive the reading of the indictment, and I guess we just need a pre-trial setting.
All right, Mr. Adams, the court will have the record reflect that Ms. Chevalier has entered a plea of not guilty into the record, has waived the formal reading of the indictment. The court, having reviewed her affidavit of indigency, finds her to be indigent, has appointed the Honorable Mitch Adams to represent her. Court hereby sets this case for pretrial on August 25th. And Ms. Chevalier, the court has also issued conditions of pretrial release. Have you been provided a copy of those?
Yes, sir.
Okay, so you've reviewed those with your attorney and you understand that those are conditions that have been placed on your bail in this case. And if you violate any of those conditions, the court could revoke your bail and put you back in jail. You understand that?
Yes, sir.
Okay. All right, once you receive your notice of appearance from Mr. Adams and you've signed and received a copy of your conditions of pretrial release, then I would just ask that you report to the pretrial release department to make sure that you are squared away before you leave the courtroom.
Yes, sir.
Your Honor, I have ready to go Stephanie Walthall.
All right, if you'll go ahead and bring your client to the podium.
Plea.
All right, this is CR 20-67 State versus Stephanie Denise Walthall.
We're ready to proceed on a plea agreement, Your Honor. I have the plea paper signed and executed here. I'm
All
sorry.
right, and it's okay, Mr. Adams, you've ensured that she has signed and her signature has been sworn at every appropriate place?
That's correct, Your Honor.
Okay, and who can, and so let's do this. Can you tell me the terms of the plea agreement, Mr. Adams?
Yes, Your Honor. Ms. Walthall is charged with third-degree felony by indictment, hindering apprehension for prosecution of a known felon. Our plea arrangement with the DA's office is that in exchange for her plea of guilty, the punishment will be assessed at 10 years confinement in the Texas Department of Criminal Justice Institutional Division, and that sentence will be probated for 4 years, and that a fine of $3,000 along with court costs will be imposed.
And what are the court costs?
Court costs are $290. Total reimbursement fees are $785.
And is there any restitution?
There is not, Your Honor.
All right, so third degree felony, hindering apprehension of known felon, 10 years probated for, $3,000 fine, $290 court costs, $785 reimbursement.
That is correct, Your Honor.
All right. All right, Ms. Walthall, if you will, raise your right hand. I'm going to place you under oath. Ms. Walthall, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, make sure you speak up as loud as you can and towards that microphone, okay? All right, thank you. All right, so you are Stephanie Denise Walthall, correct?
Yes, sir.
All right, you can't shake your head. Okay, you gotta say loudly. And Ms. Walthall, are you a United States citizen? Do you read, write, and speak the English language?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
In this case, your attorney is Mr. Mitch Adams. Are you pleased with his representation of you?
Yes,
Do you feel like you've had sufficient time to discuss your case with him, have all of your legal questions answered? Is there anything about the plea agreement that you don't understand? And Mr. Adams, do you believe Ms. Walthall to be competent today?
She's competent, Your Honor.
And have you explained to her her legal and constitutional rights?
I have, Your Honor.
And you believe that she appreciates and understands the consequences of her plea agreement today?
Yes, I do believe so.
All right, Ms. Walthall, you are indicted with the third-degree felony offense of hindering, what was that again, Mr.? Is it hindering apprehension of a known felon?
It's hindering apprehension or prosecution of a known felon. Yes, Your Honor.
Okay, I'm sorry.
Section 38.25 D is in Delta of the state.
All right, thank you. Ms. Walthall, you are indicted with the third-degree felony offense of hindering apprehension or prosecution of a known felon. That third-degree felony carries a range of punishment of not less than 2 years nor more than 10 years confinement in the Texas Department of Criminal Justice, and an optional fine not to exceed $10,000. Any type of plea agreement or sentence handed down by the court must fall within that range of punishment. Do you understand that? Okay, make sure you speak up. I'm having a hard time hearing you. So, Ms. Walthall, it's my understanding that the plea agreement in this case is that you're going to be pleading guilty to that offense in exchange for the state's recommendation that your sentence be assessed at 10 years confinement in the Texas Department of Criminal Justice, with that sentence being suspended and you being placed on community supervision for a period of 4 years, a $3,000 fine, court costs of $290, and reimbursement fees of $785. Is that your understanding of the plea agreement? And you understand that would fall within the legal range of punishment?
Yes, sir.
All right, then Ms. Walthall, as to the charge of hindering apprehension or prosecution of a known felon, a third-degree felony alleged to have occurred on December 20th of 2019, how do you plead to that charge? Guilty or not guilty?
Guilty.
And Ms. Walthall, are you pleading guilty because in fact you are guilty and for no other reason?
Yes, sir.
Ms. Walthall, has anyone pressured you, threatened you, or forced you to plead guilty to this offense? All right, the court will accept Ms. Walthall's plea of guilt. Mr. Adams, is there any objection to the admission of States 1, the stipulation of evidence?
No objection, Your Honor.
All right, court admits States Exhibit 1 into evidence and also takes judicial notice of Ms. Walthall's judicial confession. Is there anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor, we rest.
All right, and Ms. Heisel, are you going to be giving the summation of the facts?
Yes, Your Honor.
Go ahead.
Ms. Walthall lives in Wills Point, where she was contacted by Wills Point police. They came to her house to serve a warrant on her boyfriend. She advised the police that he was not present in the home, and that she would tell him to contact them. After a series of suspicious phone calls back and forth between the suspect and the police on that felony warrant, they went back to the house. She again advised them he was not there. They at that point notified her that they were attempting to serve a felony warrant, and that if she was hiding him in any way or being untruthful in any way, that she could face criminal charges. She said she understood. She insisted he was not at the home because of the several suspicious phone calls that they had received. Basically, Wills Point stayed a distance away and observed the house. And not long after they left and started observing the house, Ms. Walthall was seen loading up the car with bags of clothes, and then a hooded figure ran from the house into the car. Officers executed a traffic stop on that vehicle, and Ms. Walthall was found in the car with the suspect, essentially fleeing town.
Thank you, Ms. Heisel. Mr. Adams, any objection to that summation?
No objection, Your Honor.
All right, then based on the evidence before the court will follow the plea agreement in this case. Ms. Walthall, court finds that there is sufficient evidence to convict you of the third-degree felony offense of hindering apprehension or prosecution of a known felon. Court assesses your punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court will find that it's in the best interest of the community and the defendant for that sentence to be suspended. Court places you on 4 years community supervision. Court assesses a $3,000 fine, court costs of $290, and orders you to reimburse Van Zandt County for fees of $785. Ms. Walthall, have you reviewed your conditions of community supervision? You understand what's expected of you?
Yes, sir.
And you understand what's required of you?
Sir.
Have you ever been on probation before? And have you successfully completed probation before?
No, I haven't been on probation in a long time ago. I haven't been in trouble in 11 years.
Right, but when you were on probation, did you successfully complete it? No, you ended up getting revoked?
Yes, sir.
All right, so this is not your first rodeo, so you know what's going to happen then if you violate your conditions of community supervision. All right, so I don't have to explain to you that if the state files a motion to revoke, then we're not discussing whether or not you hindered apprehension of someone. We're going to be discussing whether or not you violated your conditions of community supervision. Is that right? All right. So the court hereby remands you to the custody of the Van Zandt County Community Supervision and Corrections Department so that it can carry out the terms and conditions of your sentence. I'm going to have you accompany my bailiff to be fingerprinted, and then you're to report to the probation department.
Your Honor, I have one more to go. When the court's ready. It is.
Yeah, give me just one moment.
Start. He said give me just a moment.
All right, Mr. Adams, I'm ready. Who are you ready on?
Diane Elizabeth Monroe Fagan.
All right, Ms. Fagan, if you'll make your way to the podium, please. This is CR 20-59, State versus Cheyenne Elizabeth Monroe Fagan. And we're set for pre-trial today. Is this a plea too, Mr. Adams?
It is, Your Honor.
All right, can you tell me the terms of the plea agreement, sir?
Certainly. Miss Monroe Fagan is charged by indictment with engaging in organized criminal activity under section 71.02 of the Penal Code. As indicted, it is a state jail felony. The terms of our plea agreement with the state is that, or are that, in exchange for her plea of guilty, punishment will be assessed under section 1244B as in Bravo of the Texas Penal Code, such that she will be sentenced to 4 days in the county jail with credit for 1 day served toward that 4 days and a fine of $1,500. Court costs amount to $270. Reimbursement fees are $785.
And is Ms. Fagan going to be going into custody today for the remainder of her 3 days?
That's correct, Your Honor. We want to get it over with.
Okay. All right. So just to recap, so it's engaging in organized criminal activity as indicted, state jail felony, being prosecuted under section 1244B, in which the conviction will be a misdemeanor conviction with misdemeanor punishment. Is that correct?
That's correct, Your Honor. Subject to correct the state's attorneys.
4 days jail, credit for 1, 1,500 fine, 270 court costs, 785 reimbursement.
That's correct, Your Honor.
All right. Ms. Monroe Fagan, if you will, raise your right hand. I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, make sure you speak up loudly so that I can hear you. All right, ma'am, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
Yes, sir.
And in this case, you're represented by your attorney, Mr. Adams. Are you pleased with his representation of you?
Yes.
Feel like you've had sufficient time to discuss your case with him and have all of your legal questions answered? I'm sorry, I didn't hear you.
Yes, sir.
Okay. And is there anything about this plea agreement that you don't understand?
No, sir.
Okay. All right. And so, Ms. Monroe Fagan, you have been indicted with the state jail felony offense of engaging in organized criminal activity. And the range of punishment as you are being prosecuted is confinement in the Van Zandt County Jail for up to 1 year and a fine not to exceed $4,000. Do you understand that?
Yes, sir.
And the plea agreement that you have reached with the state, it's my understanding that you're going to plead guilty to that state jail felony offense in exchange for the state's recommended punishment that you be prosecuted as a misdemeanor offense under section 1244B, and that your punishment be assessed at 4 days confinement in the county jail, that you receive 1 day credit for time served on this case, that you have a fine assessed at $1,500, court costs of $270, and that you're ordered to reimburse Van Zandt County $785. Is that your understanding of the plea agreement?
Yes, sir.
All right, so Ms. Monroe Fagan, then to the charge of engaging in organized criminal activity, how do you plead? Guilty or not guilty?
Guilty.
And are you pleading guilty because in fact you are guilty and for no other reason?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to something you're not guilty of?
Yes, sir.
All right, the court will accept Ms. Monroe Fagan's plea of guilt at this time. Mr. Adams, any objection to the admission of State's Exhibit 1, stipulation of evidence?
No objection, Your Honor.
All right, court admits State's Exhibit 1 and takes judicial notice of Ms. Fagan's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor, we rest.
Ms. Heisel, you prepare for a summation of the facts?
Yes, Your Honor.
Go ahead, please.
Miss Monroe Fagan is the older sister of a girl, a juvenile, who her and her other juvenile high school friends came over to the home that Miss Monroe Fagan shared with another individual, and they essentially came together to go in and assault that roommate of Miss Monroe Fagan. Ms. Monroe Fagan drove her sister to the house where they were met by the 4 other girls, and then the 5 juveniles went into the house, assaulted the roommate pretty seriously. Once interviewed by police, the co-defendant juvenile girls basically said that Ms. Fagan was aware of their intent to come in and assault her roommate. And they had made plans ahead of time to meet at the house at a certain time for her to let them in the house to accomplish that assault. And that is corroborated by the fact that Miss Monroe Fagan remained outside of her house in her vehicle throughout the assault, even when some of the juvenile girls came out and indicated that there was a fight on there, they might need some help. Miss Monroe Fagan stayed in her vehicle during the commission of that assault.
Mr. Adams, any objection to that summation?
No, Your Honor, I believe that's what the evidence would show.
All right, then based on the evidence before the court and the state's recommendation, the court will follow the plea agreement in this case, hereby convicts Miss Cheyenne Elizabeth Monroe Fagan of the offense of engaging in organized criminal activity under section 1244B. Court hereby assesses her punishment at 4 days confinement in the Van Zandt County Jail. Court awards her 1 day credit for time already served. Court assesses a $1,500 fine $270 court costs and orders her to pay reimbursement fees of $785. Ms. Monroe Vegan, whenever you are released from the Van Zandt County Jail, I'm going to order you to report to the Van Zandt County Courthouse and meet with a court compliance officer to make arrangements for you to discharge the monies that you owe Van Zandt County. You understand that? Your failure to do that may, well, not may, it will result in a warrant being issued for your arrest and you being reincarcerated for your failure to pay your fines, court costs, and reimbursement fees. All right. So you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm going to have you go with the bailiff to be fingerprinted. And then after you are fingerprinted, then bailiff, you're to take her into custody.
Your Honor, that's all I have on the docket this morning, and I don't think I'm scheduled for anything this afternoon that needs excused.
Well, do you want me to schedule you for this afternoon? I could probably do that.
Well, I already have a commitment this afternoon, Your Honor.
Fine. Be that way. Be that way. You just, if you want to go back to Tyler, just say you want to go back to Tyler.
I be wanted.
Yes, sir. Your excuse. Have a great day.
Bye, Mitch. See y'all.
All right, state, I've had an update on the whereabouts of Mr. Gimbel. Mr. Gimbel states that he has dropped the ball and did not realize he was on today's docket. And he has indicated to Miss Taberham that on Mr. Murph, that the discovery is not complete and that Mr. Murph has additional charges. And then on Mr. Xavier Williams, that discovery is ready, but he needs to pick up a disc. So I've asked Mr. Gimbel to be able to appear via Zoom, and I'm told that he has a flip phone. So Mr. Williams is there, correct? Mr. Williams, are you there in the courtroom? You are? Okay. So does the state have any kind of information for the court in regards to what Mr. Gimbel said?
Judge, I've not heard from Mr. Gimbel. I do know we have some discovery for some attorneys, so if he's been contacted to be told that there are videos ready for his pickup, then I have no reason to disbelieve that or distrust that. I know Mr. Williams's case is newly indicted, so that would be expected. But I have not personally spoken with Mr. Gimbel about either one of these cases recently.
All right, Mr. Williams, this is CR 20-70, and you are Xavier Tayshawn Williams, correct? All right, and did you hear my my announcement that Mr. Gimbel indicated he's unable to attend court today? Did you hear me state that? Okay, so what I'm going to do for you, Mr. Williams, is I'm going to reset your case, and I'm going to reset you to August 25th. The bailiff is executing a notice of appearance there to your left. Once she hands that to you, I want you to sign that, and it's going to have your new date to be back in court, okay? And if you need to appear via Zoom, then you can contact your attorney, and we can make arrangements for that, okay? So once she hands you this notice of appearance and you sign it, she'll give you a copy, and once you receive a copy, you'll be free to go. All right, Mr. Murph. All right, this is CR 20-60 State versus Colton Murph. Mr. Murph, Mr. Gimbel is not going to be present today. He indicated that he is still lacking some discovery on your case. The state's going to contact Mr. Gimbel to determine if there is additional discovery that he's requesting. Rather than keep you here all day waiting for Mr. Gimbel, I'm going to reset your case for August 25th. And you'll be set for pretrial. And if you request to appear online rather than in person, if you'll contact your attorney, then the court will grant that request for you to appear via Zoom for your pretrial hearing. I want you to sign that notice of appearance there with that reset date of August 25th. Once you have that in hand, then you'll be free to go, and make sure you stay in contact with Mr. Gimbel. And then Ms. Heisel, if you'll just email Mr. Gimbel and touch base with him on Mr. Murph and Mr. Williams, so that he understands when the case has been set, both cases have been set for the 25th, and that we need to have our discovery issues resolved.
I will relay that message, Judge. Thank you.
Thank you, Ms. Heisel. You're free to go once you have that, Mr. Murph.
Jeff emailed me.
All right, who do we have left in the courtroom back there?
Rodolfo Gonzalez.
All right, are you ready on that, Mr. Sanders?
Yes, sir, we are.
All right, Mr. Gonzalez, if you'll make your way to the podium. This is CR 17-196, State versus Rodolfo Gonzalez. Record will reflect that Mr. Gonzalez has applied for the appointment of an indigent attorney. The court finds that Mr. Gonzalez is indigent, has met the requirements, and has appointed the Honorable Jeff Sanders to represent Mr. Gonzalez. Mr. Sanders, have you had an opportunity to review the indictment with your client, and are you ready for arraignment?
Yes, sir, we are ready for arraignment, and we have reviewed the indictment. And Judge, I can tell the court his name is not spelled correctly. Talking with Mr. Gonzalez, his name should be spelled first name Rodolfo, and his last name spelled with a Z, Gonzalez instead of S.
All right, so that's Rodolfo.
Yes, that's correct.
And then the last name Gonzalez should be two Z's. Gonzalez.
Yes, that's correct.
All right, Ms. Heisel.
Judge, we would make an oral motion to amend the indictment. We can just interlineate that name change on the face of the indictment if it pleases the court.
Any objection, Mr. Sanders? No. All right, the court will grant the state's oral motion to amend the original indictment in this case to reflect the correct spelling of Rodolfo Gonzalez. And Mr. Sanders, if you will do me a favor, and if you will make that note on the appearance sheet of the correct spelling, that way when I get back to the office, I can pull that from the clerk system and pull the indictment. I'll probably forget how to spell his name. If you'll just write that on the appearance sheet, his correct spelling, then the court having granted that, the court will pull the indictment and will interlineate and correct the spelling.
Okay, I will do that.
And go ahead.
And had a chance to look at the indictment. We would waive the reading of the indictment and waive the formalities of arraignment. And Judge, we did also talk about the potential punishment range on a second-degree felony, burglary of habitation. And at this time, we would enter a plea of not guilty to that charge.
Thank you, Mr. Sanders. Court will enter Mr. Gonzalez's plea of not guilty into the record, and the court will set Mr. Gonzalez then for pretrial hearing on August 25th. I believe I've already set you on that day, correct, Mr. Sanders?
Yes, sir. I believe I have some other settings.
Okay. And Mr. Gonzalez, while Mr. Sanders is completing that notice of appearance, did you receive a copy of the conditions of pretrial release in your case?
I did that.
You did? Okay, so you understand that your bail is conditioned upon you being in compliance with each one of those conditions that have been checked off by the court. You understand that? And if you fail to comply, if you violate any of those conditions, the court can find your bond insufficient and put you back in jail. All right, so it's important that you maintain consistent contact with the pretrial release officer and be in strict compliance with those conditions of pretrial release. Once he has received a copy of his conditions of pretrial release and a copy of that notice of appearance, then he's free to go.
Thank you.
All right, State, do you see anything else on your docket that I have failed to cover? I believe I'm going to take another cursory look here. We have some, and Aaron, are you?
Sergeant Carter's gonna make that
Okay.
spot for a moment.
I didn't know the Honorable Sergeant Carter was in the courtroom. Hello, Sergeant Carter.
Good morning, sir.
All right, if you'll call these names for me,
Yes, sir.
and I don't know if you have a copy of the docket, but it'd be on the first page. First one is Richard Randall Springer. Should be about the fourth one down. Richard Randall Springer.
Yes, sir.
And then on page 2. Actually, no, I'm sorry. No one on page 2. Page 3, Karen Juanita White. Karen Juanita White. And I believe that's all.
Yes, sir. Got it.
And Ms. Heisel, it just came to my attention that I failed to discuss the victim impact statement on Mr. Llewellyn, but that has been provided to the court. And so it was notated on my docket, but I was having technical difficulties and I didn't see that. So I will get that signed and sent back for your office.
Thank you, Judge. And just for the court's awareness, that was the witness that was trying to watch via YouTube. We are in compliance and communication with that victim.
Okay, and she was she approved the plea?
It's a he, but yes.
He, okay, good. All right, well, I'll get that signed and sent back to Melissa so that she can do that.
Thank you, Judge.
All right, I think that's all we have until this afternoon, and then this afternoon I see we'll have a couple pleas. One of them will be with the Spanish interpreter, so we'll need to get that set up. Not a whole lot, it looks like. 1, 2, 3, 4, 5, 6 cases total. So I guess I'll see y'all at 1:30.
Thank you, Judge.
All right, thank y'all.
No response to Richard Randall Springer or Karen Juanita White.
All right, then Richard Randall Springer and Karen Juanita White's name has been called in the courtroom. There's been no response. Her name has been called loudly and distinctly 3 times in the courthouse with no response. Court finds that they've received notice of today's hearing. Court hereby issues a judgment nisi and alias capias. I would ask the bailiff to complete bailiff certificates, and the court will set new bail at $100,000 in each case. And court is adjourned until 1:30.
Thank you, Judge.
Thank you, Sergeant Carter. Thank you, Ms. Heisel. Thank you, Mr. Cox.
Thank you.
Ms. Grit.